We're so fortunate to be living in the
Good evening and welcome to Face to Face. For the Newsfirst team, I'm Niresh Elyathambi. US President Donald Trump shocked the world a few days ago when he announced that all ships transiting through the Strait of Hormuz must pay a toll to the United States of a whopping 20% of the value of the cargo on each of those ships. Now, had that been done, the world's economy would have been thrown into chaos because everything would have gone up in price, would have skyrocketed. Oil, which comes from the Middle East, would have immediately gone up by 20% or more. Fertilizer, the same. And when you have things like oil going up in price like that, everything else would go up in price. The world would have faced disaster. Fortunately, the very next day, he rolled back his decision under pressure from his Middle Eastern allies. So, thank goodness for small mercies. But this begs the question, what is the legal position on this? Can the United States or Iran or any other country arbitrarily impose such tolls? Because the Strait of Hormuz is not the only such passageway through restricted waters. We have many such straits all over the world. And so what is the situation in those? Because if Iran or the US starts levying tolls on the Strait of Hormuz, then other countries in other parts of the world might be tempted to do the same. And we would have a whole new ball game where international maritime transportation is concerned. To talk to us about all this, we have Mr. Nuwan Peiris, my guest tonight. He is an attorney at law who specializes in maritime law. Good evening, Nuwan.
Good evening.
Lovely to have you back on the show.
Yes, thank you very much for inviting me.
Right. So, Nuwan, first and foremost, we have many such waterways in the world. Strait of Malacca, and so many other, in Europe, in the Mediterranean, Straits of Gibraltar, and where the Red Sea meets the Indian Ocean. There's so many different such passageways. But are there any such straits where the neighboring countries are arbitrarily deciding and imposing a toll on ships which are passing through?
Yes, I think it's a good question and a timely question. I'm happy that you asked that question, because people tend to confuse this strait navigation with some of the navigations that are there through countries. Say, for example, Egypt and the Suez Canal, the Panama Canal, the Kiel Canal, St. Lawrence Seaway. So those are canals that cuts through the countries, and it is under their total sovereign control.
Then they are man-made canals.
Absolutely. There may be joint agreements as between countries, those who have come to make them as opposed to those who possess them. Like, say, Panama Canal, there was a big row as far as Trump's regime is concerned. Now, those are totally distinguishable from what we call the transit passage, which comes under international law, and that comes under the Law of the Sea Convention, which is basically governed under the international law. So don't get confused. I mean, I would like to ask the audience not to get confused with those canals that goes through, or canals or channels, man-made channels that goes through countries. Maybe they are trying to construct a new one in Nicaragua, Kra Canal in they are proposing a Kra Canal in those days in Thailand. So those are man-made canals that's like a road inside the country waterway. So that can be locked out and locked in and whatever.
So the answer is no in terms of these natural straits or passageways.
That's correct. Natural canals that are basically outside your sovereign territory, which it belongs to the canals or channels that are there in the seas.
Right. It's not within your land territory.
Yes, a waterway or a river or anything like that. So that is within the seas.
Right. Yes. Now, let's explain this further, and let's take Sri Lanka as an example.
Yes.
So if you go to the southern coast and stand at Dondra, and there is nothing between you and Antarctica, which is many thousands of miles south. For the first 12 nautical miles, it's Sri Lanka's territorial waters that belongs to us.
Yes.
And then there's 200 miles, again from the coastline, 200 miles, which is our exclusive economic zone, where no one else can have economic activities. They can't come and fish or, do mining of the seabed and so on. Right. So that's very clear.
Yeah.
Now, if a cargo ship carrying, whether it's oil or timber or vehicles or whatever, if a cargo ship goes through our territorial waters, that is within 12 miles, let's say, just say 5 miles away from land,
Yes.
can we charge a toll? Do we charge tolls on that?
You are not supposed to, and you can't, and no country does. Even USA, take it from me, even USA, because the passage, I mean, what the seas that as you quite rightly said, I mean, I'm very impressed with your knowledge of the law of the sea. You are right. What we have is the territorial sea that extends to 12 nautical miles from the baseline. What you said, the coastline, that is correct. And you have what we call the innocent passage regime. So the passage must be innocent, and we have sovereignty in territorial seas, subject to one limitation. It gives to the flag state or the shipping, the one that gives the flag to the ship, to basically navigate through the territorial seas free of any encumbrances. We call it innocent passage. It has to be expeditious and continuous, and innocence is a prior requirement. So as long as you go expeditiously and continuously without stoppage, you have that right of innocent passage as a cargo vessel, as the example that you took.
Right. So, of course, within that area, the 12 nautical miles, our Navy, our Coast Guard would have the authority. So if there was some illegal activity going on, our authorities would have the right to stop the vessel, to inspect it. It could be something like just, polluting the sea by dumping waste.
Yes.
It could be smuggling something. It could, there are various, issues which might crop up.
Yes.
But otherwise, a ship is free to pass through.
Yes.
And the same goes, obviously, for the EEZ, the Exclusive Economic Zone.
Let me intervene there. As regards EEZ, we have the high seas regime of navigation. So, because EEZ, our jurisdiction is only to explore and exploit and conserve and preserve the living and non-living resources. It is a resource-based jurisdiction. Those are economic rights. Our sovereign rights are
12
limited to, sovereignty goes up to the territorial seas. We have only sovereign rights in the EEZ, that is also economic rights. So we can't do anything for as regards the navigation. That is the high seas regime, being high seas regime of navigation, freedom of navigation being incorporated into the EEZ. So it's a dual regime, kind of sui generis regime.
Yes.
Yes.
But in all of this, no tolls. However, if a ship enters Galle Harbour or Colombo Harbour, then there are tolls on the services provided by our...
That's a brilliant point, because then the ship, the moment you enter the port gates, I know that's sea, but then the moment you enter from the port gates, you are in the internal waters. We call it the internal waters regime. There you can charge, right? But still, even the courts have held that whatever that goes in has a right to come out, right? Because that is called the vertical passage and horizontal passage in innocent passage. There are cases from the International Tribunal for the Law of the Sea. So it gets deeper and deeper. So whatever that goes in has a right to come out. So that argument is being brought for even whenever you go into these man-made canals inside, whatever you go in can come out. So that is called basically they have technical terms. So basically the innocent passage is basically the horizontal passage where you go through the coastline or the baseline. So that is what it is. And importantly, no levies or taxes can be imposed on those vessels.
Right. Now here's where the situation might seem to get a bit tricky.
Yes.
We spoke of the 12 nautical miles, and a nautical mile is slightly larger than a mile, but just take it as a mile. Seafarers, of course, would take issue with me, but being a landlubber, well, let's just say a nautical mile is almost equal to a mile, but slightly larger.
Slightly,
right. So you have 12 nautical miles. Now, where you have two countries, let us say Malaysia and Indonesia, and the Strait of Malacca.
Yes.
And if so you're assuming 12 nautical miles for Malaysia, 12 for Indonesia. Now, what happens if the strait doesn't have 24 nautical miles? At a certain point, it may not be that wide. In which case, then obviously the two states would have to sit down and discuss and come to an agreement. And I believe with the Pork Strait, we have something like that between India and Sri Lanka. And in other parts of the world, countries sit down and do this. So then you don't get 12 on either side. You may have less. But still for all, no one's levying at all.
Yeah. Let me clarify this. Now, all this while we were discussing about a case simpliciter. That is, you have what you call a state, and you have 12 nautical miles, and you have a 12 nautical miles territorial sea with sovereignty, embedded into that. Now, what you are talking about is strait navigation, which completely is outside the scope of what we call the territorial seas regime, because the strait is on top of your territorial sea. Now, this is a complex situation. So what happened was that the framers of the Law of the Sea Convention said, right, let's discuss about a different regime, right? Because what happens is sometimes the strait is, as you said, less than it may be a few kilometers, right? See the Bering Strait, for example. So now this is a tricky situation because these are choke points. Now this is where the negotiations became heated as regards navigation. So what happened was that they said, okay, we will have this new regime in part 3 of the Law of the Sea Convention called Straits Passage, right? Or what we call the transit passage. Now there the rules change. If this Malacca Strait or Bering Strait, or as in our discussion,
Bering Strait is between Russia and the United States or Alaska.
Yeah, that area. And then you have Malacca Strait, one of the most important choke points, or Taiwan Strait. So there they said, no, we will have another regime, and this is the standard we are going to apply. All the vessels can go through. It has to be continuous, expeditious, and non-suspendable. Regime applies to all the ships that goes. Now the transit passage regime is more liberal than the innocent passage regime, right? And it is much closer towards the high seas right of navigation, you see. So that means now, for example, now in innocent passage in territorial sea, innocence is a prior requirement, right? You must be innocent. But in transit passage, you don't have to be, innocence is not a prior requirement. You can have what we call the normal modes of navigation. Say, for example, if you are doing innocent passage, if you are doing an innocent passage journey through territorial seas, right? If you are in a submarine, you have to basically surface. You can't travel, you can't navigate submerged. Whereas on the other hand, if you are in a transit passage, I told you that the regime is much closer towards the freedom of navigation in the high seas. You don't even have to surface. The submarine can go underwater. To that extent, we have liberalized what we call the requirement of innocence and said, we don't need even the requirement of innocence. As of right, you can navigate. So you can see that the transit passage is so important that they even created a regime that is closer to the high seas navigation. So the question of levying tolls like in the Hormuz Strait doesn't even arise under the Law of the Sea Convention. That is what our people need to recognize, because I see in the media that people are using innocent passage through Hormuz Strait. No, that is transit passage. It's a different regime, different rules apply. Just because Singapore and two countries get together and agree, and you can't close it. Sri Lanka and India can't get together and close the strait, right? Neighboring states around Hormuz can't get together, even with agreement, close it to the other side. So even sometimes, maybe even Mediterranean, there is a passage where you can enter, say Gibraltar and say Morocco, some kind of countries, they can't get together and close the what we call the Mediterranean Sea. That is a critical point that they did. I mean, you can't just neighboring countries come and close the shop. You can't do that.
Absolutely. So this is all established law.
Yes.
Because human beings have been traveling by boat and by ship for thousands of years.
Yes.
And these issues have come up from time to time.
Yes.
Where states or city-states or whatever will try to exert some authority, and then, of course, there may be wars. But in the end, it's common sense, isn't it? Because in the end, the world needs the commerce.
Yes.
The global economy must flow. So that's the be-all and end-all of it. Not in sort of being like, some crackpot regime which says, let's get more money off the ships which are... it's sort of like saying, okay, we're importing a lot of vehicles, so let's get a lot more money into the state's coffers by, hiking the duty by 200-300%. It's self-defeatist in the end. So you can't allow these states which are close to these straits or passages to dictate terms.
Absolutely, yes.
That's the bottom line.
Yeah, under the international, under the convention of Law of the Sea Convention 1982, remember that. That is the convention that is applicable for the state and for those countries that have ratified it.
Right.
Yes.
Right. Now, I'd like to draw your attention to something very peculiar. When Mr. Trump said this a few days ago, it jogged my memory about something called the Barbary Wars. Okay. There were two Barbary Wars, and this was about 225 years ago. The Barbary coast is the coast of North Africa, Morocco, Algeria, Tunisia, and Libya, I believe. And there were pirates, and there were pirate states on those coastlines, and ships of other countries which passed through the Mediterranean or the North Atlantic side of Morocco. They had to pay a toll, which was protection money. It was like Al Capone and Chicago. You want to go this way, you pay a toll. And many European states had been paying these tolls. But a new country which had just been formed, called the United States of America, decided they're not going to pay the tolls. And what followed was the first Barbary War, which was from 1801 to 1805, and then the second Barbary War in 1815. And the US Navy came all the way across the Atlantic and defeated these pirate states and ensured freedom of navigation for everyone. And the US government did not at that point say, well, we've ensured freedom of navigation for everyone, so everyone should pay us a toll.
Yes.
They did not say that. It was two wars in the cause of freedom of navigation for everyone. So it struck me as particularly ironic that the leader of this same country, 225 years later, tried to turn around and say that, well, the US Navy is ensuring the safety of these ships, so we're going to charge 20% as a toll, which, certainly Mr. Trump has not learned his US history. Perhaps he should look it up on Google.
And I'm impressed with your US knowledge. I think maybe you should give a lecture to him, because I mean, I'm really impressed with all the state practice that you are quoting.
Well, I'm afraid he has not asked to come on the show yet.
That's a good one, yeah.
Right. So this is the tradition
Yes.
over the last few centuries,
Yes,
and people don't argue about this.
Yes.
It's accepted. Only recently, with Iran saying that they're going to levy tolls,
Yes.
and now Donald Trump saying they're going to levy tolls, has this issue come up at all? So we need some clarity on this for the whole world.
Yes. Yeah, I mean, I think I was really impressed the way you quoted the state practice. Now, this is what is relevant here, because the critical point is that neither the USA nor the Iranian regime is part of this Law of the Sea Convention. Now, that takes the game to a whole new level. Maybe Trump would have read some internet article and he would have figured out, well, I can do whatever I want whenever I pleases. So this is the problem. I think he did not basically consult his advisors on this point. Because if you...
Trump generally doesn't listen to his advisors, and I don't know whether his advisors even bother to advise him. Because the very next day he walked this back. So, yes.
Yeah. So in such circumstances, what happened now? Now, this is where all the legal minds would come in and discuss. Now, you're not part of the established legal regime, that is 1982 convention, that is the Law of the Sea Convention in 1982. So what happens? Now, there we have what we call the general international law, and we have what we call the customary international law, which even USA is bound. Now, what is the customary international law? Now, customary international law, one of the important ingredients of customary international law is the state practice, which you beautifully quoted. What has been the practice of the United States of America? They have been fighting towards the, basically freedom of navigation. Right? Because, for example, now this customary international law was initially recognized in Corfu Channel case. There was a case between the United Kingdom.
That's an important case that you are speaking about. But first, we need to take a short commercial break. Don't go away. We'll be right back after this. Welcome back to Face to Face. I am with attorney at law Nuwan Peiris, who specializes in maritime law. Now, Nuwan, let's discuss the situation when a country is not party to an international convention. And there are dozens, hundreds of international conventions covering everything from child labor to nuclear arms and, maritime navigation, everything. You name it, there's an international convention. And there are 193 member states in the United Nations. Now, not all of these conventions are signed by everyone.
Yes.
Some countries have certain interests and they say, well, we'd rather not be part of this. Or they're not even interested in something. It's pertaining to, let's say, Antarctica, and a country in the middle of the Sahara Desert wouldn't really care about it. So they may sign, they may not sign. So it's rare that you'll get all 193 countries. But usually you get a majority of countries, or at least 50 or 60. And in any convention, global convention, there is a threshold when the learned people who write these conventions, they do come up with a number of states saying, okay, at 50 states or 60 states signing up, the convention will become operational. And that may take a couple of years to get 50 or 60 states signing up, but then it becomes operational, and even after that other states may join. So over a decade or 2 decades you might end up with 150 nations signing up. Now, what about those nations which don't sign up?
Yes.
Of course, if they have nothing to do with, if you're in the Sahara Desert and it's something to do with Antarctica, it doesn't matter. You're not going to flout that. But what happens if you do have some impact, such as the United States here? The USA has an impact all over the world, but they are not party to a lot of conventions. The International Criminal Court, for example, they are not party to it. So that's caused severe problems, which is ongoing, because the US government is frequently clashing with with the judges, right, saying they have no jurisdiction over the US. Right, but in this particular case, what happens now? The US, you said, is not party to this wonderful convention, and the book is right here. I certainly haven't read it, but you, I'm sure, have. So what happens at that point? Isn't it? Is it a situation where a country can say, "Oh, we'll do whatever we want," or is it more prudent to say, well, if the rest of the world is doing things this way, maybe we should not rock the boat?
Yes. I think basically this is where you basically stir the hornet's nest. Now you have not ratified, as United States, the Law of the Sea Convention. Now what happens? Is there a case of what we call non-liquid, no law? No, it doesn't, because United States is a party to the fundamental charter called the UN Charter. Now, the UN Charter has set up what they call the ICJ, International Court of Justice, and the ICJ statute talks about certain sources of law to apply when you don't have anything to apply, when you don't have the treaty law to apply. So, just because the treaty law is silent as a source of law, then you go into other laws, right? General principles of international law, and you have what we call the customary international law. Customary international law, for instance, what is customary? What is our practice? What is our practice, basically? What do we think is our practice? What you call the mental state of the nation. And the customary law is basically the mental state of the nation plus the state practice. So basically it's state practice. So customary international law, what is the customary international law position that applies to the law, to the United States? That is where the issue ends up. Now, you gave a very interesting example. That is, you quoted these old wars, and that really set the state practice of the United States. They have been basically a interventionist with regard to the freedom of navigation. Right? You beautifully quoted. Now, that is what the International Court of Justice will look into. And they did look into this matter in 1949. There was an interesting case called, as you quite rightly said, Corfu Channel case. It was UK versus Albania. The first case that International Court of Justice got soon after it was set up. It was an interesting case. Albania set up, now by this time, remember, Law of the Sea Convention has not come up. So the judges have to actually invent law by looking into the state practice. So those brilliant judges, right, thought about it, because at that time this innocent passage concept was not very clear. And later on, only after this Corfu Channel case, that we had this dichotomous regime called transit passage and the innocent passage regime in the 1982 setup. So this Corfu Channel case, what Albania did was they set up some land mines, so what you call sea mines, because they were at war. So UK happened to pass by, and then finally what happened was their vessels were destroyed. And then the matter was brought before the International Court of Justice. And the International Court of Justice said, no, this is a channel and you have a right of navigation. And Albania has breached it because, remember, you see, you have to ensure, even in your territorial waters, right, innocent passage is available to the innocent, what you call the other flag state. Because UK at this stage is the flag state, because their flag-bearing warships went through. So it is with that case that the concept of innocent passage became developed, and later on the principle was taken by the International Law Commission. They further debated on that, and then they drafted the first convention called the Territorial Sea and the Contiguous Zone Convention, where they recognized this regime called innocent passage regime. Again, it is not clear whether it should be different from the transit passage. In 1982, they gave further clarity by introducing this transit passage and innocent passage. So what happens to USA now? Now, USA has not ratified the Law of the Sea Convention. So now, but the customary international law position is represented in the Corfu Channel case. So going by the Corfu Channel case and looking at the transit passage regime in Part 3 of the Law of the Sea Convention, they will say, no, even the Part 3 of the Law of the Sea Convention, although you have not ratified, they might probably say this forms part of the customary international law. It is now the state practice. Even if you don't ratify, it is applicable for you because it's so universal. There's an unbroken chain of countries following it. So given that, there is a high possibility if a nation state brings a case before, if they dared enough to bring a case before the USA to the International Court of Justice, they may probably say that Part 3 of this Law of the Sea Convention, although you have not ratified as a state, it reflects the customary international law. If it is customary international law, you are bound by that. So that would be the situation. So I think the Trump's regime need to be mentioned about this concept called customary international law. I mean, they know they have top class experts. I don't know whether the leadership is willing to listen to that. If it goes before the International Court of Justice, they're very likely to say, no, this court has precedence, that is Corfu Channel case, and it has developed through the convention, and we take it as to be part of customary international law. That might be the situation. It's very likely that would be the case. Remember that, they will look into the state practice. Even when Law of the Sea Convention was negotiated in 1982, they negotiated for about 10 years in the 70s. It was USA who proposed that transit passage, a more liberal passage closer to the high sea right of navigation, should be there. They are the people who tabled the motions and kept on arguing it. Although later on, when I think it was Ronald Reagan came, they decided not to ratify. So because USA froze their international position with regard to the Law of the Sea as it stood at 1980 with regard to the convention negotiations. So if you look at it, it is USA who pushed for this transit regime, which is a more liberal regime than the innocent passage regime. So it is very likely, given their state practice over a period of time, starting from the Barber War that you talked about, ICJ might say, or probably say, no, all this is part of customary international law. So the convention provisions with regard to transit passage would apply irrespective of whether you have ratified or not. Why? Because it is now part of the customary international law. That would be the legal situation.
Right, and you referred to in the Corfu Channel incident that the Albanians had laid sea mines
Yes.
In a channel where other countries'
Yes.
ships were passing through
Yes.
with disastrous results.
Yes.
So we have such a similar situation now
Yes.
with the Strait of Hormuz, where Iran did sow sea mines,
Yes.
and they started removing them, or they said they started, and the European nations were going to also help them, and then of course we are now back in a state of war, so that hasn't happened. But the very act of placing sea mines in such a passage in the Strait of Hormuz is itself illegal,
Yes.
at least in the eyes of customary international law. You cannot just go chucking sea mines all over the place. India and Sri Lanka can't do that in the Pork Strait. Indonesia, Singapore and Malaysia can't do it in the Strait of Malacca. It's just not allowed.
Yes, absolutely. I mean, that's the point. And in retaliation of the fact that they have laid landmines, right, USA responded by saying, no, I am going to levy taxes for those people who go through. That is an economic retaliatory measure involving force. Even that too is inconsistent with the Corfu Channel principle. Because I'll tell you what, if you read the Corfu Channel case, they said Albania is in breach of, impeding the innocent passage through this particular strait. But thereafter, what happened was UK, as a show of aggression, went with their mine sweeping vessels and did a cleanup. Right now, and then that point was also addressed by the ICJ very beautifully. I mean, top judges at that time. They said, no, your second act as the United Kingdom, retaliatory tactic, is also against international law. That is a show of force, because you had time to come before us and get redress. That is not self-defense, right? You have done it on your own volition. It's an act of aggression. Your second act, UK's second act, is not consistent with international law. You see, it was very beautifully done. It was a very balanced decision. Yes, Albania lost the case on the first round, but in the second round, they won it because of the UK's aggression. So as regards to this UK's levying of taxes or whatever the economic aggression that he is going to do so, right, is again against the principles of Corfu Channel case.
Right, the US attempt to levy a toll. Yes. So it's very interesting that this, this freedom of navigation through these channels has been a very vital issue. It's been recognized as a vital issue for centuries, because it's very easy for any country to sabotage a region or the whole world just by closing such a strait. I mean, if you imagine the Strait of Gibraltar, or that connects, it's between Europe and North Africa. Or if you take the entrance to the Black Sea from the Mediterranean, which is controlled by Turkey. That's Bosphorus, the Dardanelles, Sea of Marmara, and the Bosphorus. So if Turkey were to suddenly decide to close that, about a dozen countries which are on the Black Sea would be isolated. So these are very vital aspects which have been dealt with over the centuries. So you can't sort of show up like Donald Trump and the Iranians, and say, we're going to do this, we're going to do that.
Yes.
It doesn't work that way.
Yes, there's another point I need to add, because I mean, you are really into this, so I will explain this point also. Now they will say, no, I mean, there's a war going on, that's why we are doing these retaliatory tactics to each other. So then it comes under what we call the international humanitarian law regime, because third states are affected now. Because the previous problem of Corfu Channel is as between two states getting involved, and yes, now there's an interesting situation where even the third parties are getting affected. Now what? Can you apply the Corfu Channel principle? Now that brings us to that advanced stage of thinking. Now there what happened was, these are considered under international humanitarian law regime. You see, we call them belligerent states. Two belligerent states acting each other, throwing stuff at each other. Now, what about the neutral party states that has to do so? Now, there what we now this is a gray area. So, what happens is how the Law of the Sea Convention applies during the peacetime. Now, during the when there's an international engagement like this, the international humanitarian law regime is separate, because so they will say, no, this is international humanitarian law, so Law of the Sea Convention doesn't apply. So we need to act in retaliation of what Iran is doing. That is what the USA will say, and so will Iran. Iran will also come with their own explanation. So now we are in another conundrum. We have get into another, basically, a difficulty. Now, how do you come out of this quagmire? There what happened was, some jurists have got together and formulated a guideline called San Remo Manual. Right, San Remo is a city in Italy, if I'm not mistaken. So those great jurists have got together and developed a guideline as to what to do if there is a international law engagement. I mean, a humanitarian engagement. I mean, a kind of a war. What would you do? Now, there in that San Remo Manual, they say even the belligerent states, right, should not conduct the war in such a way that prejudices the rights of the neutral party states. So the neutral party states should have the right of passage, right? So now, San Remo Manual is not really law. That is what we call, basically, it may reflect even the customary international law position or even the general principles of international law. But it has been practiced. I mean, San Remo Manual is applied as a guideline by many navies in many states. So although it is strictly not law, there is a great possibility they may examine that principle. That is, ICJ may examine that principle and say there is a customary international law rule saying that the neutral states rights of the neutral states must not be prejudiced by the two warring belligerent states in the Strait of Hormuz.
Right.
That is likely, the issue might come to that level.
So, of course, when two or more states are having a war, it's always wise for neutral states to stay away from that area, their planes and their ships and so on. So, for example, airlines have, given Iran and that whole region a wide berth since hostilities began. So that's prudent. But there are other routes. They can go north of Iran, south of Iran, and reach, if they're going from, let's say, Colombo to London, they don't have to overfly Iran. So they take another route.
Yes.
But in the case of the Strait of Hormuz, the oil, the fertilizer coming out of the Middle East, the Gulf states, there's no other alternative.
Yes,
so
exactly.
Neutral states need to send their ships in and bring those same ships out loaded with that cargo.
Yes, brilliant. That is why we had a separate regime. That is why even US argued that, if you try to close the seas, what we call the mare clausum, if you try to close the seas, this is the problem that will occur. That is why they negotiated a regime that is much closer towards high seas right of navigation. And you brilliantly mentioned a point called the right of air flight. Now, air flight, I didn't mention about it due to lack of time. Now, with regard to the innocent passage regime in the territorial seas, ships have innocent passage, but not not the planes. You don't have overflight because in a matter of few seconds, the craft is, the aircraft is inside your country. That's why they don't give, even under the innocent passenger regime in the territorial seas, you don't have right of overflight. Now, in the transit passage, you have the right of overflight. Even through the transit passage, you can have the normal mode of air navigation. So to that extent, that regime is protected with regard to the rights of passage. It's closer to the high seas regime of navigation.
So that's very interesting. And as you pointed out, the US did champion these rights in the past. So it's so ironic that it's going back on what it championed, and the rest of the world has to sort of tap it on the shoulder and say, listen, buddy, you can't do that. You were saying something different a few years ago. So we hope that Sena Council will prevail, don't you think?
Yes. Yeah, absolutely. I wish so, because I believe that Donald Trump may be playing the field or try to create so much of chaos that sort of maybe he wants all the world to get involved and then lift their burden out, because they are trying to come out given the political situation that they have to face midterm elections and all that. Maybe I think he himself has got into a quagmire. He's messed up and he's trying to mess it up even further and thereby see what's going to come up. So I hope that Vice Council will prevail, because he has retracted from the statement now. I'm sure after a few days later he might say something similar to that once again. So we'll see.
Yes, you certainly can't predict Mr. Trump's train of thought. And I'm afraid we'll have to leave it at that because we are out of time. My thanks to Attorney at Law Nuwan Peiris, a specialist in maritime law. Thank you very much for giving our viewers a very vivid description of the exact situation with regard to the rights of passage of ships all over the world, including the Strait of Hormuz. And thank you very much to you at home for watching, and I'll see you next time.
වෛරයේ සටන ආදරේ වෙස්මුණ දාගෙන මම දිනලා පෙන්නන්නම්. ආරෙම නේද යාගේ නම? ලස්සන නම.